Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case? And gave you the reason for why he was stopping you, asked for your information. You gave him your phone and I copied down our information. I then asked her for insurance. You smelled marijuana in your vehicle. Now the next thing, do you have any children?
No, ma'am.
Are you employed?
Yes, ma'am.
Because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal.
He just cannot abide by any of the court orders that are set before him. So I have great concerns. And especially given the violent nature of this case. Then to the other number, we have 23 calls that were completed since his privileges were revoked to different pins. And in one of these calls as recently as Monday.
Mia Herrera.
Present, Your Honor.
Thank you.
Morning, Your Honor.
Morning. Good morning. All right. All right, the court is calling 2025 CR 003690 State versus Mia Herrera. Could I have parties announced?
Deputy Pitlar for the state of Texas, Your Honor.
John Sanheim for Miss Herrera.
All right, and probation, this is an application. Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor, I have.
Court will find that the state is in compliance with discovery. Ms. Herrera, did you review the application for deferred adjudication with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do so waive it.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Herrera, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with evading arrest, detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea in this case?
This moment captures the solemn weight of the admonishment. The judge does more than recite rights. He warns Herrera that evading arrest with a vehicle is no small misstep, but a felony that could lock him away for 2 to 10 years. The courtroom air feels heavy, yet Herrera remains composed. He calmly waives his rights, admits guilt, and allows his attorney to affirm that he fully understands the consequences. It is a striking scene of order and clarity, where the law speaks plainly and the defendant accepts it without resistance. But beneath this calm exchange lies a pivotal uncertainty. Is Herrera seizing a rare second chance, or quietly stepping onto a road that ends with far harsher consequences?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Herrera, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state recommends deferred adjudication. There's to be a TAP evaluation, follow whatever recommendations, MRT and defensive driving. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There has not, Your Honor.
Outside the agreement, the state is requesting that your community supervision be for a term of 2 years, and there be 100 hours of community service restitution. Did you understand those were recommendations from the state, and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
State offers State's Exhibit 1 and all attachments at this time, Your Honor.
No objections, Judge.
All right, state, you may be excused. You're welcome. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same.
Yes.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
At this time, no, Your Honor.
All right, so why didn't you pull over?
I did pull over.
No, evading arrest detention in the vehicle is when officers, ask you to pull over. And they signify this by putting on lights behind your vehicle and asking you to pull over. So the officer in the police report said that he asked you to step out of the vehicle and you took off. And then finally, they end up having to break your window once you pulled over again. So do you not remember this night?
No, I pulled over. I just didn't feel safe to get out of my vehicle.
Well, no, that's not what the police report says. Have you read the police report?
Yes.
What it says is, they do the normal, he's driving, he approached your vehicle and gave you the reason for why he was stopping you, asked for your information. You gave him your phone and I copied down our information. I then asked her for insurance.
At this stage, the case shifts from procedure to something deeper. The plea has been entered. The terms are set, yet two competing truths hang in the air. Herrera claims he acted out of fear, a man overwhelmed and desperate to protect himself. The police report tells another story, a driver who deliberately fled and resisted. The judge does not allow this contradiction to fade. He confronts Herrera with it, insisting he face the distance between his explanation and the record before him. This is no longer routine paperwork. It is a test of accountability. Deferred adjudication in this light is not just mercy, but a mirror, reflecting whether Herrera's words truly align with his actions.
While your window was rolled down, he says there was a very strong odor of marijuana. I told AP I had to return to my vehicle and that I would be back. He contacted his supervisor. And then he gave you more instructions. You refused to follow his instructions. You rolled up your window. He said, hey, I'm going to add more charges. You need to exit the vehicle. You refused and you drove away. I immediately contacted dispatch and informed them of the situation. I returned to my vehicle and started following AP with my emergency red and blue overhead lights and siren on. You continue to travel, and he actually puts in here every street that you pass. And then you finally pull over, and he asked you to step out. You didn't. And then he had to draw his weapon. You still wouldn't step out of the vehicle. And he told you, I'm going to have to break this window to get you out of the vehicle. You said, nope, not getting out of my vehicle. And then he ends up having to break your window. So I don't understand what you mean you were not evading. I mean, if you feel as though you're not evading and you want a jury trial, you're welcome to have a jury trial.
I'm content with where we're at as far as
So why didn't the officer had pulled you over. He wanted your license, your insurance. Why didn't you remain there, give him all the information? What was going on with you? Were you using drugs? Were you intoxicated? What was going on? I'm trying to figure out so I can set appropriate conditions for your probation.
I didn't feel comfortable or safe with the officer. I understand that me driving away was not the best decision. It wasn't the correct decision. And I understand if there's ever a point that I don't feel safe around an officer, that's not the approach to take. I truly just did not feel safe with that officer.
All right, and if you're drug tested today, what are the results going to be? And you're going to get drug tested today.
I haven't smoked within the past 2 weeks, so it's gonna be positive, I'm assuming, because I don't know how long it takes to get out of your
Mhm.
system.
So the officer was right when he said he smelled marijuana in your vehicle. Now the next thing, do you have any children?
No, ma'am.
Are you employed?
Yes, ma'am.
The Herrera case illustrates how a courtroom becomes a crossroads between law and human truth. On paper, her actions satisfy every element of felony evading arrest, a crime carrying 2 to 10 years behind bars. Yet the judge, rather than reaching immediately for the harshest penalty, honors the plea bargain through deferred adjudication. This choice is far from routine. Before granting it, the judge forces Herrera to confront the gravity of her conduct and the cracks in her explanation. She insisted she fled out of fear, but her admission of marijuana use casts doubt, hinting at motives less noble. Even so, her willingness to admit fault and acknowledge that she chose the wrong path carries weight. That self-awareness becomes the fragile foundation of her second chance.
What do you do?
I'm a server
Where?
at Mia. It's a sushi restaurant.
Oh, I'm your sushi. Do you make any of the sushi or you just serve?
I serve.
Okay. All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication, regular reporting by Zoom or in person. There's going to be regular random UAs. Let them know that they need to test for levels. After today, there's to be no driving until you present a valid driver's license and insurance to probation. There's going to be field visits 1 time per month for 3 months. Proof of employment within 30 days, no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be 100 hours of community service restitution. How far did you go in school?
High school.
All right, what are you
Diploma.
planning on? What are you planning on doing with the rest of your life? What's your dream job?
A flight attendant.
All right. So there's 100 hours of community service restitution. If you become a flight attendant, your community service hours will be deemed satisfied. So you need to start making plans on how you can do that.
Thank
My
you.
understanding is you sometimes get free travel.
I have a question.
Yes.
I've applied to be a flight attendant with this current situation going on. I guess I know I probably should do my own research on it, but is
Yes.
this something that, like, after the deferred probation happens?
Well, what I can tell you is this is on your record. You need to discuss with your attorney, perhaps about non-disclosures or whether or not it can be removed from your record, expungements. Okay?
Okay.
Probation, is there anything else? Is there anything else you need from the court to be successful?
And just so I understand, the 100 hours, if I become a flight attendant, I don't do them, or I still
Yes.
have to do them?
No, if you complete that, you're off to the friendly skies.
So,
That's much
So,
better, Judge.
Otherwise, you can do the 100 hours. They usually will put you in the sun picking up paper.
is the 100 hour, or do I have like the 2 years to figure out to become a flight attendant? Is that what-
Yes.
Okay.
All right, is there anything else?
Just one last thing, Your Honor. In discussions with the state is not going to, I just want to place it on the record, the state is not going to oppose an early termination application if we should so apply.
All right.
Thank you,
Thank
Your
you.
Honor.
All right, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal.
Mia Herrera was charged with evading arrest, a serious felony that could mean years in prison. She claimed she pulled over but didn't feel safe getting out, while the police report said she deliberately fled. The judge carefully considered both sides. In the end, Herrera received 2 years of deferred adjudication, no jail, but strict probation, regular check-ins, drug tests, field visits, employment verification, 100 hours of community service, and restrictions on contact with minors. She admitted her mistake and committed to follow the rules. The decision feels fair. Herrera wasn't let off lightly, but she was given a structured second chance. The court balanced accountability with an opportunity to rebuild, making the outcome reasonable and humane.
Thank you for dressing appropriately for court. If there is some issues you have or you're confused about anything, let your probation officer know. If you feel as though they're not addressing it, you can always come back to the court.
Okay, am I able to give them the car insurance and the ID today?
You'll speak to probation and they will let you know.
Okay.
All right, thank you.
Your Honor,
Thank
thank
you.
you so much. I appreciate you.
All
I
right,
appreciate you.
you. Have a good one.
You as well, Judge.
Calls the case of the people versus Hanky.
Your Honor.
Good afternoon, Your Honor. Attorney Kevin Hassan, except
All right, it's your motion.
They probably motion to take the previous PCC hearing. My client's bond vote from privileges from the jail suspended due to allegations that he cut off his tether and contact with the complainant. Following that particular bond hearing, I instructed my client to not contact the complainant witness period in the jail. I also instructed my client that if allowed to be back on bond, we would ask the court to hopefully to reinstate his original bond tether. I would note that he has no prior criminal, no prior adult felony conviction whatsoever. Following the submission of my motion, I did read the people's response, which I guess there's been allegations that my client had contacted the complainant subsequently. Now, I just found out today some transcripts. Obviously, people address this. Some of the language that was used during conversations, I don't have phone conversations myself, but I will admit that it seems that my client had contacted the complainant even after his bond. And so I say this, Judge, again, I know it seems like my client is kind of throwing up his middle finger to the court.
Oh, yeah. He is.
But Judge, I just would state that this young man, I think he understands now that the court orders are serious, that the court orders him to do something it means. So Judge, I'm just asking, I guess, for some leniency to trust that Mr. Hanky will comply. He had a $75,000 cashier bond that he was able to post to a bondsman. The only thing I can ensure that if the court were to give him a second chance, he would not violate his bond, even if the bond is a house arrest with strict conditions. So Judge, I am asking the court to reinstate his bond, and if the court is unwilling to do so, I would at least ask that his phone privileges be allowed back on to at least contact family. Does he's never had any contact with his family, his children? He hasn't been able to contact his dad, caretaker for. And so at the very least, the restriction on his phone privileges to contact family.
All right, Bill, before I hear from the people, counsel, let me just say,
The hearing with Hanky really shows how tricky it can be to balance patience with enforcement. On one hand, his lawyer paints him as a young person who has made mistakes but deserves a second chance. On the other, the record is clear. He's ignored court orders and acted irresponsibly after previous hearings. The judge's pointed question, "Where's our tether?" makes it obvious that any leniency won't come without conditions electronic monitoring or house arrest could be required. In the end, Hanky's next steps don't hinge on what his lawyer says, but on whether the court truly believes he's ready to follow the rules this time.
you came in here the first time, and, well, let me start with this. Where's our tether?
From my understanding, Judge, I thought community corrections still had it. I thought they had become.
He cut the tether off. We haven't seen it.
Okay.
And I know you made the representation to the court, but I know you wouldn't have personally known that. I'm sure that came from your client or something along those lines. We don't have the tether back.
Okay.
Then, and I get you're making the representation saying your client's going to follow what the court says, but I don't know if anything can be as shocking as walking into a court free. Your bond gets revoked. You get put in jail because of something that you've done. And then you still go about violating the court's order. I'll be honest with you, counsel. I mean, I get what you're saying. I don't have a problem giving people chances. I just don't know that this is the one to give a chance to. Because he just hasn't done anything the court's asked him to do. Ms. Senda.
Your Honor, I will rely mostly on emotion. However, in listening to his jail calls, he has 45 total calls to one number after his privileges were revoked with different pins he's using. Then to the other number, we have 23 calls that were completed since his privileges were revoked with different pins. And in one of these calls as recently as Monday, there were a few memorable quotes that I heard in the calls, such as, "There's not shit in this world that's going to stop me from talking to you, man. Nothing in this world stopping me from you. I don't give a fuck what nobody says about none of that. I'm going to be calling until my court date. They're not going to do shit. At the end of the day, they can't do shit. I'm going to talk to you till I can't talk to you no more. I'll be home. I'm not worried, man. I know I told you this is about to be my last call, but I'm not stopping shit. I'm not stopping nothing." And then, why stop now if they already know? So I have extreme concerns that he cannot follow court orders, considering he cut off his tether, continued flagrantly calling the victim with other pins, both numbers, acknowledging in some of the calls that he should not be contacting her, and continue to contact her. He just cannot abide by any of the court orders that are set before him. So I have great concerns, and especially given the violent nature of this case as well.
The judge's skepticism makes perfect sense in this situation. Hanky's lawyer asks for one more chance, but the record tells a different story. He cut off his tether, ignored restrictions, and made dozens of prohibited calls, all while openly admitting he knew these actions were forbidden. Statements like "nothing in this world's going to stop me" don't just reflect youthful recklessness, they reveal willful defiance. Actually, at this point, the court isn't just questioning whether Hanky can follow the rules, but whether he ever truly will. The facts suggest that showing leniency could end up rewarding a blatant disregard for judicial authority.
Anything else, counsel? I mean, counsel, does your client want me to just request of the jail that they put him in solitary so that he has no contact with anyone, can't use their PIN number? If he thinks we can't do something, and if particularly you're going to look at this judge and think I can't do something, young man, you're going to learn a big lesson.
So I definitely don't want that. My client.
Well, he needs to, and I don't mean to interrupt you, counsel, but he needs to understand. You can say all that stuff. You are not that big, not that bad. Now, if you want to play with me, this is the kids say, mess around and find out. I guess that's not the quote, but yeah, it's close, but I did pretty good. I said it okay, right now. All right.
So just, if I may, just briefly, my client would like to.
Go ahead.
I want to apologize. I don't think I'm being bad at all. It's very about myself. I can't say that I'm not in here for nothing. You obviously think I am. Yeah. I just want to apologize. Like I said, I'm not being bad. I don't want to be here at all. I really don't. Truly. Again, please show mercy. Please. So,
I have no problem showing mercy to those that deserve it and have earned it. You have not. Motion for bond reduction or any change is denied. His bond will continue as revoked.
Thank you, Judge. And for the record, this is also, from my understanding, the PCC.
Yes, sir. Is all discovery complete?
And I would ask if possible, if possible.
People have their witnesses available on the first.
We'll do our best, Your Honor.
Preliminary examination in person will be set April 1st, 2025, 9 a.m. in person before Judge
Harry.
Perry.
And Your Honor, I did want to make it clear where I did contact the jail yesterday and they have blocked both of victims' new numbers and old numbers, so there should not be any more.
More calls coming through.
In this case, Marisa Hanky repeatedly violated court orders, including cutting off her tether and continuing to contact the victim despite restrictions. Her attorney asked the court for leniency and reinstatement of bond, arguing she would comply going forward, but the judge was unconvinced. Given the clear pattern of disobedience and the serious nature of the underlying case, the court denied the motion and kept her bond revoked. This was the right decision. The judge balanced mercy with responsibility and made it clear that ignoring court orders and endangering others will not be tolerated. It's a firm but fair reminder that accountability comes first, and second chances require demonstrated trustworthiness.
All right. Thank you.
Thank you very much, sir.
Thank you, Your Honor.